Nika, and I am so honored to be with you this morning and just take you through a couple of the legal essentials. Our thanks goes out to Mido and the organizers for giving us this opportunity. And I hope that the session does bring you um, some peace of mind. It will be interactive. If you do have any questions, please do not hesitate to field those for us, and so we can respond. Or if you do need to chat later, then we will give you our contact details and we can maybe take the conversation further. I'm going to share my screen. I will also be putting my camera off for the duration now of the presentation. I just wanted to make sure that everybody sees my smile, and big ups to Colgate. All right, so once again, welcome. And today we'll be focusing on contract law. I'll be taking you through a couple of the essentials required in contract law, and especially in business. It's a major part of business from the onset of business right until engaging with clients, with staff, with suppliers as well. And so today I thought that would be a great start for us to look at. And my colleague Pindile Mapaso, she'll be directing the conversation more on the basis of credit agreements and the application of the National Credit Act, which I'm sure would bring you a lot of benefit, either in for those of you that are giving credit, or even for those that are applying for credit. So a little bit about our firm, and just to give you an introduction, KHR, Kakana Sulatswayo Khadebe, was incorporated in 2002. We currently have 3 directors. Our managing director being Mrs. Sophie Tabang Pepi Kakana. She's very well known and has acted as a judge and sits on a number of boards, including being a co-curator at the Municipal Councillors Pension Fund. We hold a level 1 triple BEE and 100% Black female owned. If you want to find us, our offices are situated in Sandton, Johannesburg. We are directly opposite the Discovery Building on Catherine Street. And we also have a satellite office in Nelspruit in Mpumalanga. We currently have a staff complement of 30, and that puts us in the medium-sized law firms. Our tagline is "Every client matters," and our mission, our vision is to ensure that our clients are seen, heard, and understood. Our specialties include commercial and corporate law, insolvency law, cyber law, insurance law, medical malpractice law, administration of deceased estates, and family law. As you can see, that we have quite a vast area of specialty, so that caters for all of our clients' needs. And we have in-house attorneys that are specialists in those fields. So if you do need to make contact with us, please do so. Let's get into today's topic, and as I said, we'll be discussing contract law and an introduction into contract law. For those of you that have either studied BCom or a law degree, this might be a refresher. For those of you that don't know, I think it will be helpful in terms of understanding what are the requirements of contracts. So what is a contract? And a contract is an agreement between 2 or more parties that creates a legal obligation. The agreement can be concluded either verbally or in the form of writing. And this is the tough part. Maybe I could share with you at this stage. One of my clients was concluding a contract with the supplier in the construction industry, and they were sitting at a Wimpy, and they kind of decided, well, the best way to put down all of the details would be put it down on a napkin or a serviette, because they didn't have any paper to write on. And coincidentally, the contract didn't materialize. My client tried to go back to the details of the serviette, but it was not sufficient to actually conclude a contract, and we'll get to that a bit later. So here's a question. I'm not too sure if we can put out a poll, but when is the best time to contract? Is it before a partnership or a relationship starts during the term of the relationship or after the term of the contract. I'll leave you to maybe type your answers in the chat quickly for maybe, can I give you 30 seconds just to see what your thoughts are. When is the best time to contract? All right. Anybody wants to take a before? Yeah, Tulisiwe says before. Same time after parties agreed. Cedric, thank you. Anybody else? So the best time to contract is is before the relationship actually begins, and the reason for that is, and you would know that for some of you that are married um, or have been divorced, it's very hard to contract when the parties are at odds with one another, and the terms of reference have changed. So whenever you get into a relationship, try and put down good terms as soon as possible, so that the both parties have an understanding. Thank you for that, Tulisiwe and Cedric. All right. So, what are the essentials of a contract? What needs to be part of a contract? The first one is there needs to be an offer and acceptance. Someone needs to make an offer, and the other party needs to accept that offer. This is the cornerstone of a legally binding contract. And please keep that in mind, a legally binding contract. Consideration. This refers to the value exchange between the parties, which can be in the form of money, goods, services, or a promise to act or refrain from acting. So the contract details are very important, and the parties must have considered those details in order to enter into the contract. The third one is an intention to create legal relations. So the parties must intend for the agreement to be legally binding. That is a very, very important part. The next part is there must be a capacity to contract. The parties must have the legal capacity to enter into a contract, meaning they have sound mind and not minors and not disqualified by law. So in this sense here, sound mind, meaning that the person is not mentally incapacitated. They are able to appreciate the details of the contract and the content of what they are entering into. Secondly, minors do not have the capacity to contract unless they are aided by guardians or their parents, or they've been emancipated. And then finally, not disqualified by law. So that would normally take place where a person is sequestrated and they would not be able to enter into a legally binding contract or under curatorship until they get the assistance and the authorization of the curator of the estate. Finally, the legality of the purpose. The object of the agreement must be legal and not against public policy. A great example in this sense is a person can contract to have someone killed, but unfortunately, that is against public policy, and so cannot be upheld to be a legally binding contract. In the Latin term, we'll say it's contra bonus mores, contrary to the morals of public society. All right, let's go into the next section. All right, so the requirements of a valid contract, and just to bring it back, there must be consensus, there must be an agreement between the contracting parties. The parties must have intended the agreement. The parties must have the capacity to contract. And this also goes in the form of capacity where a director or an employee of a firm must have the authorization of the company in order to contract, or the organization to contract. That's normally done by a resolution, where a director's resolution is completed. And so a company resolution is completed and gives them the ability to contract. The agreement must have certain and definite terms, and then finally, it must be lawful. This is where most of our businesses actually fail in terms of contracting well. The aspect of certain and definite terms. When we are contracting and we do not have the skill to contract and put the ideas that we have in proper contracting terms, it is highly probable that at a later stage, when something needs to be queried or questioned, a person or the person that has been disadvantaged may look to raise technical defenses in the way that the contract has been drafted. And there is a very long section in our LLB degree for the interpretation of contracts and the interpretation of statutes. And so it's very, very important that it's done skillfully and with someone that does have knowledge. So the type of contracts that you and I would be exposed to on a daily basis, commercial agreements, that includes your shareholders agreements, goods and services agreements, employment agreements. These are very, very important to have in place and in accordance with the current law. Non-disclosure agreements, especially when you're going into joint ventures or going into partnerships. Non-disclosure agreements are very, very important to set the standard for that. Credit agreements, which my colleague Pendilia will reflect on. Insurance agreements. These are quite extensive in today's times due to the fact that insurance has become a major product, not only in the personal space, but in the business space. And then, of course, anti-nuptial agreements. So those of you that are married and married in community of property, you know that you share 50-50 in profit and loss. For those of you that are not married as yet, I would suggest that you would consult an attorney on drafting an anti-nuptial agreement to safeguard your interests as well as that of your spouse in the event of your business turning or times taking a tough run. Right, so the clauses in the contract, and these are important. These are not the end all of all contracts. These are the essential clauses that should be in the contract. The description of the parties and the capacities in which they act in, definitions that are specific to the contract in terms of technicalities or timeframes, the purpose of the contract, why are we contracting, what was the basis of us contracting, then the details of the terms of the agreement, when, where, and how it will take place, who will be responsible, and then also, if we look at in terms of payments, when will payments be made, will interest be levied, are there costs, and so on that are involved. Then, of course, we have the breach clause. The breach clause kind of dictates as to how a person that has been disadvantaged by non-performance of the other party and how they can go about raising the breach clause, what will be the outcomes, a cancellation clause, what would be the grounds for canceling the contract, and what else can a person claim for, which we will cover in the next section. A penalty clause, so that will cover the aggrieved party. A non-variation clause, a very important clause. A non-variation clause is a clause that's incorporated into the contract that basically states that unless the parties agree to something, to an added clause in writing and have signed that off, then only will that come into play. However, if this non-variation clause is not in, and if you have a verbal agreement, then one can raise that, and that becomes very sticky, especially when argued or queried in a court of law. Alternative dispute resolution, in the event that we are not in agreement on certain terms, instead of us going into a court of law, can we look at other ways of resolving the dispute? This is very important as well, because if the terms of reference are not dictated to in the agreement itself, in the contract itself, you might find yourself in a situation where the parties are unable to agree on the terms, and that can delay the outcome of a matter or even the appointment of an arbitrator. So please consider that when entering into your agreements. And then finally, the signatures, the date, and the place as to where the contract was concluded. Very, very important, especially when it comes to issues of prescription and or when time frame should be allowed and served. Right. So the rights of a party who is subject to a breach. So this is an aggrieved party. They have the right then to either cancel the agreement, claim specific performance by the defaulting party, or claim compensation for the damages suffered. This is very, very important to understand, especially when you are having difficulties in the performance of the contract. Now, where can we get this done? It normally takes place in terms of the process via letter of demand. A letter of demand then places the person that has breached the contract on terms, giving them a specific amount of time in which to remedy the breach. If they do not remedy the breach, then can then take this matter on into a court of law, either through a summons by action or through an application process where they will be able to claim these aspects. The only difficulty, though, is in terms of quantifying it. And so at sometimes you will require the services of an expert who will have to quantify those damages for you. Please also consider that when looking to raise a breach as well. All right, so after you concluded a contract and it is in play, it's important to set times for reviewing and renewal of the contracts, especially like your service level agreements and so on, because from time to time, the law around the contracts does change. And it's important to be compliant at that stage. You don't want to be in a situation where your contract is outdated and or does not speak to the current circumstances of the law at the time of any breach or difficulty taking place. So legal compliance is important. Avoid ambiguity. And this is the difficult part because everybody reads and interprets differently. What we want to do is to capture the true intention of the parties at the time of them entering into the contract. And this sometimes also goes as far as ensuring that the people that were a part of the conclusion of the contract can give testament or can give witness to what was concluded at. This may be other members of your boards or employees that were part of it, just to give effect to that. And then finally, value for money. So for example, your service level agreements are concluded, but it's not reviewed. And in 3 or 4 years' time, the cost of your expenses have increased and your fee should have also increased. And so you're losing out on your money there. All right, I'm going to pause here and take any questions that you may have in terms of the content that I have provided before I hand it over to my colleague Pindile. Boitumelo, is there anything from your side?
No, there is nothing from my side. If anyone has a question, they can raise their hand or type it in the chat box. We have Cedric. You can unmute your mic or just type the question. It's up to you. Cedric, your mic is muted.
Okay, can you hear me now?
We can hear you now.
Oh, no problem. Thank you very much. Thank you for giving me the opportunity to raise this question. And also, I thank you, Mr. Naika, to share this nice presentation with us. So I just want to ask, and it's sort of like, I can say an advice maybe, or it's a question, I don't know. But if in terms of service level agreement, when is the best time to have that service level agreement on table? Let's say I have a client and on this client, I'm happy he's taking my service, but then I forgot to put the service level agreement on place. So is it possible for me to do that service level agreement after, or how can you advise on that one? The second one, it's what they expect or what the things that we should look at when we're drafting a service level agreement. Thank you.
Thanks for that question, Cedric. In fact, I think in today's society, the service level agreement is quite common amongst clients and suppliers. So if you've already started an engagement with your client, you can then look to reduce those terms into writing. It would be best to do so simply to cover the expectations, the rights and the obligations of the parties. So I would then suggest and recommend that you do engage with your client, advise them that you are going to be reducing the terms into a service level agreement, or SLA, and then look to negotiate those terms going forward. Also very important, make sure that you do review those terms on a yearly basis as a minimum, so that you don't find yourself the back foot at a later stage. Then the second part, you asked what terms should be included in the service level agreement. So the essential terms are what is going to be providing, for what period, who will be responsible for those services, and then finally at what rate. Also important to that, and you would remember that we'd look at the breach clause, the cancellation clause, and the non-variation clause. Those are very, very important to have that in the service level agreement. And of course, the alternative dispute resolution. So if there is a problem, we're not running to the courts, which is quite an expensive process. We can try and mediate it through a different method. Does that answer your question, Cedric?
Oh, yes, thank you very much. I get it right.
Okay, great. Thank you for the question. Anybody else?
It seems like there is no one else, so Pindi can continue with the presentation.
Thanks, Boitumelo. All right, thank you, everybody. I'm going to hand it over to my colleague, Pindile Mabaso, who's going to take us through the 2025 and look at the National Credit Act. Pindile.
Good morning, everyone. Thank you, Simon, for that nice introduction to the essentials of legal contracts. It does indeed take us back to, especially on my side, it took me back to my third year at varsity. Thank you for that, Simon. It is always a privilege to be part of these MIDU's workshops, and I'm so excited to be part of this workshop today, this particular discussion today, and that is just to be able to empower small businesses, try and help them or assist them to navigate the legal landscape and approach the year 2025 with that confidence that their house is in order. Let me just see if I can put on my camera, and I think we can get started. Yes. Good morning, everyone. I'm hoping after this conversation, Colgate or Sensodyne will slide into my DMs for some sort of sponsorship or whatever arrangement. Because yeah, I heard that Simon was showing off his smile, so here I am as well with my smile. But yes, I will now switch off my camera. So before I proceed, thank you, Boitumelo, for that introduction. And when you read my profile, it was very nice, sounded very nice. My name is Pindile Mabaso. I am from KHR Attorneys and an associate there. I hold a master's degree in insolvency law, and therefore I specialize in insolvency, and including consumer insolvency, not just cross-border insolvency, including consumer insolvency. And for today's discussion, I'll be focusing on the National Credit Act, right? So going into 2025 as a service provider, and actually some of you might be credit providers, and you will see as we go through the slides that actually your business might be extending credit. So as a service provider, you might want to actually review some of your contract that you have in place. Like Simon said in the previous slide, that there are certain contracts that you want to review, like see if there are any renewals due and all of that. So especially your high value contracts like your SLAs, supplier agreements, contracts, those agreements are very important for your business. So you want to sit down each and every year, like, I don't know, maybe like once or twice a year, sit down, review them. In that way, you can see that, okay, this one is due for a review, this one is due for cancellation, because some of the agreements actually have cancellation clauses, and you want to know, okay, for this one, in order for it not to automatically renew itself, I need to cancel if you want to cancel it. Otherwise, you'll be sitting with like penalty fees and all of that. So it's very important for your business to just take time every now and then, go through all your contracts, your key contracts, and identify key areas that you want to review or renew. So yeah. And I think due to time limits, when I was having conversation with someone and we were preparing, we said, you know what, we only have 1 hour, so let's not focus on too many things. So today's discussion will just focus on one of these high value contracts, of which is supplier contracts, and in particular the ones that fall within the ambit of the National Credit Acts, and that's the one that we're going to focus on today. So yeah, the National Credit Act, number 34 of 2005, it does not apply to all credit transactions. Its application is guided by specific provisions depending on the nature of the transaction that you have, the parties involved in that transaction, and the type of credit agreement that you're dealing with. Typically in South Africa, we have 4 different type of credit agreements, but the 4th one actually is a combination of the 3. So here I listed 3, the main ones, which is credit facilities, credit transactions, and credit guarantees, right? And the main aim and purpose of the National Credit Act, it is to protect natural persons and also smaller businesses when they enter into agreements with these bigger corporates, so that they, to just avoid these exploitative credit practices that we find, because remember, these are huge entities. They already are legally equipped. They have all the necessary resources that they need, and they know what to do when they enter into certain agreements and all of that. So the National Credit Act is there to protect people who do not have, such powers, such resources. So that's why it's there. So it afford protection for natural persons, everyone in South Africa, but also smaller entities, smaller juristic persons. Right. And also the Act, it applies to only specific, like I said, people. It doesn't apply to everyone, and also like goes with the transactions. Not every transaction will be form part of the National Credit Act. Some transactions are just too large to form part of the National Credit Act and be afforded that protection. So let's look at some of the key factors, or what gives you that information that, my business actually, in as much as it's a small business, but I might be extending credit, I might be affording credit to individuals. So these are some of the things that you just want to look at. And if you answer yes to these, then you are definitely a credit provider. All right. So you are a credit provider if you undertake the following: to supply goods or services, or to pay an amount or amounts as determined by the consumer from time to time to the consumer, or on behalf of, or at the direction of the consumer. And that is either to defer the consumer's obligation to pay any part of the cost of the goods and services, or to repay the credit provider any part of the amount contemplated in the above paragraph. 2, to bill the consumer periodically for any part of the cost of goods or services, or any part of an amount. So basically, this definition, if you want to know if you are a service provider or credit provider in your business, if you supply goods or if you render services, and in that process, you don't request upfront payment for you to render services or to supply goods, or you don't request payment immediately after you've provided your services. However, you defer the payment. You defer payment, and in addition to you deferring the payment, you levy interest. So if your business is structured like that, you are definitely a credit provider. So one of the things that you want to take note that this act only applies to transactions that levy interest. If you don't levy interest, in as much as you can defer payment, but if it's just a service and a charge or fees that do not levy interest, then it's not a credit provider. You're not extending credit. So it's very important that as an indicator, if you're a service provider, that you levy interest, you defer payment and then you levy interest. So that's what makes you a credit provider. So loans from our family members, when like your father, your mother decides to give you a loan, and they don't charge interest and all of that, that is not a credit agreement. Besides the fact that you guys are dealing not at arm's length, but also the manner, like the transaction itself, is not a credit agreement. All right. So now that you've identified whether you're a credit provider or not, if you are, then definitely, you have some compliance issues there, and you need to make sure that you comply in terms of the National Credit Act, because there are penalties if you don't comply. So one of the key requirements for you to be a credit provider in South Africa is that you need to register as such. Previously, there was a threshold to say that if you have there's so many credits or debtors in your book, then you need to register. But then after the case in 2016, the Constitutional Court decided that regardless of the number of debtors you have in your book, you just need to register as a credit provider. So that was changed in 2016. You need to register as a credit provider. And some of the practical checklist that you just maybe want to check on your business is, do you have a written agreement? And also in that routine agreement, do you charge, interest? Do you charge certain fees? Do you charge, you just look at, do I charge for this service? And do I charge interest? What are the fees and all of that? And also you want to look at the financial threshold of your business. Is it like a small juristic person with a turnover amount or asset value that is less than 1 million rand a year, or all of those things? Those are a checklist to see if you're actually a credit provider and what you need to do if you've established that you're a credit provider. So yeah, interest-free loans and all of that, like I said, they are not part of the NCA. They're just normal loan agreements, so you don't need to worry about that. And then there are, like I said before, that not all credit transactions form part of the NCA. Some are excluded from the application of the NCA. For example, like large credit agreements that are concluded by juristic persons that have, a threshold, whether it's a turnover or asset value of above 1 million rand. Definitely, you are a huge juristic person, so you don't need the Act's protection. Because it's assumed that you have all the necessary resources to make sure that you protect yourself when you enter into certain transactions and agreements. And then loans that are provided without interest, as I said earlier, that if you provide loan and you don't charge any interest, then definitely you are not your transaction does not form part of the NCA. And transactions that are not credit agreements, where you're purely just not extending any form of credit, like cash purchases, donations, there isn't any credit that is being extended, and pawning transactions where there is no transfer of ownership, and also once-off loans provided by private individuals, not in the business of credit provision. So here again, your family members, when they loan you certain amounts and it's just a once-off transaction, then those transactions do not form part of the NCA, and there is no compliance in terms of the NCA. Right? Yes. And then once you've established that you are a credit, a credit provider, and obviously maybe you did not comply, it's a very serious offense. And some agreements may actually be declared unenforceable. So that will set you back financially in your small business. And also there are fines, sometimes, and imprisonment up to 12 months. So definitely compliance is very, very important once you've figured out that you are a credit provider. And then there are other credit agreements that are still form part of the NCA. However, they are exempted from the requirement of registration. And those agreements, we call them incidental agreements. And the indicators of incidental agreements is that you provide goods or services over a period of time, and still you defer payment, but then interest is not levied immediately on that process where you defer payment, but interest is levied upon default. So if you provided goods and services and you said payment is due in the next 3 weeks, and then in the next 3 weeks, and then the data does not comply, does not give you payment, then only then you can start levying interest. And then that kind of an agreement, we refer to it as an incidental agreement. And the compliance requirements actually are very, they're not so strict as normal credit agreements. So you will just take note that if you have these two indicators where you provide goods and services and you only charge interest upon default, then there will be an incidental agreement, and then you don't have to register as a credit provider with that kind of an agreement. And then we thought you might also benefit from, the legal processes, like when we institute legal proceedings against a debtor under a credit agreement. What is expected from the person who's doing collections or from the credit provider. So at pre-litigation, before you issue summons, you need to issue a notice in terms of Section 129. And in that notice, it's very important that obviously you inform the debtor that they are indebted, and they are in default of their financial obligations, and also you advise them to rectify it. And one of the things that you would actually advise them is to seek assistance, either maybe go for debt counseling or debt dispute resolution. And that notice has to be delivered via registered mail. It's a very strict requirement from our court, or can be delivered by hand. And in the event that when the consumer or the debtor, after they've received that Section 129 notice, and they opt to seek assistance, and they decide to go for debt counseling or debt review, then your legal proceedings will be suspended until the debt review process is resolved. So that is basically just the process. And and another highlight, I think it's just something that is new in our National Credit Act, prescription. So it's prohibited to collect against a debt that has prescribed, and you actually get into trouble when you are a credit provider and you insist on collecting against a debt that has prescribed. It's a fine, it's an offense. You can be fined for that. So that's very, very important also to take note of, because like I said, the NCA, it aims is to protect natural persons and smaller businesses. So this is one of the things that the government legislature actually considered, that what, we need to protect debtors. Credit providers cannot collect against debts that have prescribed. I don't know if there's still more slides, Simon.
I think that's our last slide, Pindile. But maybe you can reflect on the aspect of prescription, so that everybody's aware of the time frame, and what does it mean that a debt has prescribed? I think we've got about 2 minutes left there, just to reflect on that.
Okay. So normally in any, like in normal legal proceedings, so now I'm looking at normal agreements. I'm not looking at credit agreements. I'm looking at normal agreements like your loan, whatever. So we do have prescription, and for a debt to prescribe, you for you to get your money, to collect your money, you have 3 years, to do that. After 3 years, you can't. So you just have to make sure that you start your legal proceedings from the day you find out that this person owes you. But one of the big difference between normal collection and collection under for credit agreements is that normal collection, your debt can actually prescription can be interrupted. That's what they call it. Prescription can be interrupted. So I can issue summons and serve you with them, and then if the moment you respond, you acknowledge that you owe this credit provider, then prescription is interrupted. So there's like your normal litigation with normal agreements, but in particular with credit agreements, it's a bit different. Like I said, NCA is designated in like specifically to protect smaller businesses and also like natural persons. So with credit agreements, you cannot do that. You cannot try to revive a debt that has since prescribed. It's against the law. Where else, like in like in the ordinary course of litigation process, like with normal agreements, sometimes you can just take a chance and do that, but you still might be in trouble if like someone takes issue with that. But with credit agreements that are like fall part of the NCA, it's strictly prohibited to do that, and it is an offense. So it is very important that as soon as you become aware of that debt, you take necessary legal action. And when I say necessary legal action, I don't mean a letter of demand. I mean, you have to issue summons and serve them. That's what is going to interrupt your prescription. After 3 years, then definitely your debt is prescribed, and you just have to let it go. I think that's about it. I think now we can take any questions. I hope that you found the conversation insightful and fruitful for your businesses, and also just for your personal gain as well. I think we can take questions now.
Thanks.
I don't know.
Thanks, Pindile. I think let's hand it over back to Boitumelo. Our contact details are on screen, and please don't hesitate to reach out, and we can take our conversation further. If you need any assistance, please don't hesitate, and we'll definitely assist you. Thanks, Boitumelo. It's up to you.
Thank you very much, Pindile and Simon, for this presentation. I just wanted to find out, is there anyone that has any questions, or are you still typing it in the chat? May you kindly raise your hand if you do. Okay, it seems like the presentation was clear and straightforward. Thank you once again. From my door to KHR, we really appreciate it. And tomorrow we have a workshop. The topic of the workshop is sharpening your brand strategy. It will be run by our senior manager at MyDo. She's a designer, a brand builder, and her name is Kenisi. So let's be ready for tomorrow's workshop, as she'll be running it. And thank you everyone for joining us. We really appreciate it, and goodbye.
Thanks, Boitumelo. Have a great day.
Thank you, Boitumelo. Thanks, everyone.